The committee of parole is reconvening at 10:40, and the next vote location is Allen Correctional Center. With the staff at Allen, please introduce yourself.
Good morning, this is Deputy Warden Brent Thompson.
Assistant Warden Jesse Bellamy.
And Assistant Warden Crystal Simon.
Good morning, Wardens. How are you doing today?
How y'all?
How you doing?
Good, good. Would your offender please introduce yourself and give your Department of Corrections ID?
My name is Sedric Jackson, 528515.
Thank you, Mr. Jackson. Let me pull up your information and we're going to get started, but let me explain the process to you. I'm going to read some information to put it in the record. We're going to verify that information. Then we'll give Warden Washington a chance to make remarks on one of the other wardens if they'd like to make some remarks and observations. And then you have guests in the hearing room, and they will be allowed to make statements on your behalf. Before we vote, we will give you a chance to make a brief statement on your behalf. You understand the process?
Yes, sir.
Mr. Jackson, you are currently 51 years old. You are a third felony offender. Your offenses are, all three of them are in East Baton Rouge Parish. And on April 25th, 2008, you were convicted and sentenced for possession with intent to distribute cocaine, and you received a 25-year sentence. Another count of possession with intent, possession of cocaine, and you were billed as an habitual offender, and you were sentenced to 25 years. And then another possession of cocaine that you were sentenced on March 16, 2009, and you received a 3-year sentence. That sentence was to run consecutive to the other two sentences, so your total sentence is 28 years. Your parole date was September 12, 2013. Your adjusted good time date, August 17, 2031, and your full term date, September 9, 2023. Is all that information correct?
Yes, sir.
All that information is correct. So I'm going to recognize your guest in the hearing room. With the lady in the black jacket, introduce yourself and give your relationship to the offender. You can keep your seat.
Sedric Jackson, the daughter of Sedric Jackson.
Okay.
My name is Douglas Walker, General. I'm his office.
Okay. Young lady that's sitting down. You ready? Would you give your name?
It's John. I'm that's your Veronica Jackson, and I'm his sister.
Okay. Ready?
So Rita. City.
Your mother.
Friend.
Okay. Okay. Young lady next to.
Sydney.
Okay. And young man.
Mark Jackson, his brother.
Okay, so we have your mother, your daughter, a friend, and
Uncle.
an uncle, okay? And your Diane Harris will be speaking, and it's Kieran
Jackson.
Jackson. Your daughter will be speaking. Okay?
Yes, sir.
And at the very end, you will be allowed to make a statement before we vote. You understand the process?
Yes, sir.
Your case has been assigned to Mr. Freeman. Would you please answer Mr. Freeman's questions?
Yes, sir.
Okay, good morning, Mr. Jackson.
Good morning.
How long have you served on this charge?
15 years and about 20 days, 11 days, 15 years and 11 days.
Okay. And what's your educational level?
I have a GED.
Okay, did you get that while you were in prison?
Yes, sir. With LTI, a juvenile facility.
Okay, okay, good. And you're 51 years old, correct?
Yes, sir.
Okay. Most of your offenses are drug offenses. Were you a drug user or a drug dealer or both?
I just sold drugs.
Okay, did you ever use drugs?
No, sir.
Okay, never in your life did you use it.
No, sir. I tried marijuana when I was younger. But no,
All
sir.
right. Just make sure we are clear, you know, just tell me the truth today, okay? Because that's gonna
Yes,
have a
sir.
lot on my decision.
Okay.
Okay, so you said you just sold drugs, you didn't use them. What's the largest amount you think you ever sold?
Probably a couple ounces at a time.
Couple ounces at a time.
Yes,
What's
sir.
that going for these days? What you used to make on a couple ounces?
Well, back then, when I was selling drugs, I was selling for like $500 a piece.
Pretty good little business, okay? And you had a cookhouse, correct?
Yes, sir.
Okay. What do you think that did to your victims on the street? What if somebody sold drugs to your daughters? I see you have two of them in support of you today. How would that make you feel?
Well, I try to read them right and give them the right directions as they growing up. But it'll make me feel bad. But at the end of the day, I would hope they wouldn't do it. But that, you know, they have their own decisions to make.
Okay, while you were in prison, I mean, you have federal charges too, right? You have a detainer on you?
Yes, sir.
I think you got a 5 years federal prison and then 3 years probation. Is that correct?
Yes, sir.
So when you leave here, you'll be going, get signed up and do some federal time.
Yes, sir. I have like 2.5 years left on that.
That's on the federal charges, okay?
Yes, sir.
Your arrest record, it dates back good ways. I think you were 19 years old when you first got arrested. Is that around correct? Do you think that's about how old you were?
As an adult, yes, sir.
Okay. What were you arrested for as a juvenile?
Armed robbery.
Okay, and what you did on that stayed in till you was 18 years old?
I had till I was 21, but I went, I did an AWOL when I was like 19, and they caught me like a few months later, and I went back and did the rest of the sentence till I was 20 and a half years old.
So how long was that sentence?
I stayed more than roughly probably about 4 years altogether.
4 years in juvenile.
Yes, sir.
You spent 4 years in juvenile, you didn't spend 15 and a half in adult. How much of your total lifetime you think you spent in prison?
Probably over 20-some years. It's been a long time, sir.
Okay, I mean, tell me why should I let you out? I mean, are you getting tired of all of this?
I'm tired. Yeah, I'm tired. I'm ready to come out and be a productive citizen in society, raise my grandkids, and try to keep them out of this situation that I put myself into.
Yeah, I see you had a lot of battery charges. Have you ever taken anger management?
Yes, sir.
What did that teach you?
It taught me to think, slow down, and assess the situation before you react. And think for both participants that's in the situation. And that way you can always avoid trouble. You think the situation out, and you can talk it out. Depending on the attitude, and have a decent conversation instead of being aggressive all the time.
When was your last parole hearing? In 2018?
Yes, sir.
All right.
Yes,
Okay.
sir.
And what classes have you taken since that last parole hearing?
Well, I took living in balance, anger management, and 100 hours.
And you took inside out dads also?
No, sir. I took a class called Malachi Dads. I never
Malachi.
took inside. Yes, sir.
That's my fault. Okay, you have 4 children, correct?
Yes, sir.
Do you have contact with all your children?
Yes, sir.
Okay, about how often y'all speak? Or they visit?
Well, I ain't visited since
Wow.
I haven't had a visit since the pandemic. Since they left the ban on that pandemic, but I talk to them pretty often, all 4 of them.
Okay. All right. What's gonna be your transition plan? Where you gonna live? What you gonna do after you get finished with the feds?
Well, I'm planning to go live with my sister, and I have a job at a roofing company. I'm gonna do that until I get myself together, and I'm working on getting my Quicks card and go back to OSHA and try to get back in the plant and get back to doing iron work in the construction field.
Ironwork's a good field, I can tell you that much. Make some good money.
Yes,
And you say you don't need a sobriety plan. You never used drugs. Have you used alcohol?
I drunk alcohol before. Yes, sir. It wasn't like no everyday thing and that.
So you don't consider yourself a drug addict or an alcoholic?
No, sir.
You've had 15 write-ups, you're medium custody. Your risk needs is low. When was your last write-up?
In 2021,
And what was that for?
cell phone.
Okay, when was your last one before that?
In 2020,
That was for a cell phone also, correct?
yes, sir.
But it means you've been approximately almost 2 years without a write-up. Okay, Ward, what can you tell me about Mr. Jackson?
Yes, sir. Jackson and I spoke on just on Monday. Had a pretty good conversation. He's doing pretty good down the walk. He's contributing to the population. Currently now he holds a job as being a painter inside the dormitory. He's doing pretty good. We're helping get some housing units look pretty good around here. But I also suggested to him that he needs to get as many self-help classes as possible to prepare him for going out to society. And that's pretty much what I suggested to him the other day. But besides that, he's doing pretty good.
Okay, any particular self-help classes you think he needs, Warden Tom?
Not really. I really believe that he need to get as many substance abuse classes as possible. He say he wasn't actually a user, but I just believe that's to help prepare him just in case he have to go back into society.
I kind of agree with that. Okay, I have no further questions, Mr. Roach.
Ms. Warren, I have a question. Mr. Jackson, I was on your panel in 2018, and I'm looking at the write-up that you had since then. And in 2018, that was the main reason. So help me understand your motivation for having a cell phone in 20 and 21. What was going on?
I ain't gonna lie to you, they're addictive. Once you get one of them in your hand, being in prison, it's like it's hard to let go. You got to put it in your mind and in your heart to really just let it go. But I ain't gonna lie, it's addictive. It's
Okay,
addictive.
I appreciate your honesty.
Yes, ma'am.
But and when you were on parole, committed this offense, you on federal parole when you committed this state offense? Were you
No, ma'am. I was off of federal parole.
off federal parole?
Yes, ma'am.
Oh, okay, all right. So what is it gonna take?
Well, I had to make my mind up.
Let me say that we would like to see you demonstrating, you don't like the rules, I don't like all the rules that I follow, you don't like them, or you just don't. But you gotta follow them because you're trying to get somewhere to this beautiful family. So help me understand, what is it gonna take?
Well, I had to make my mind up and just let it go. There come a point in time in your life where either you're gonna do right or you're gonna do wrong. I'm tired of doing wrong because every time I end up in the same situation. And I realized that and I came to my senses. If I keep on doing the same thing, I'm gonna get the same results. I'm tired of getting the same results. I lost my mother in prison and my grandmother. So I'm tired.
So you got tired after the November 21 write-up. Is that what you're telling me?
No, man, I ain't gonna lie to you about that. I was tired before then, but like I say, that cell phone was just addicted to me. I was tired of getting in trouble doing the wrong thing. I knew that having that cell phone was wrong. But I still possessed it because I was kind of addicted to that. I done let that go now. I done been over that. Like I had a chance to get another one and I didn't do it.
I'm glad to hear that. I'm glad to hear that. Because you're looking at the big picture now. You're looking at the bigger. So tell me 3 reasons off the top of your head why I should vote to let you out.
I'm ready, ma'am. I'm ready.
One, what's the other?
Ma'am.
I said, that's one. What's the other 2?
Man, it's hard to come up with another one. I just know I'm ready. I ain't gonna lie to you about that. I'm ready. Okay. I can't come up with 3, but I can come up with 1.
Okay, if it comes up during the hearing, just kind of raise your finger and we'll get to you. Okay, if you come up with 2 other reasons why I should vote for you, just kind of raise your finger and then they'll let me know that we'll come back to that question.
Yes, ma'am.
That's all I had, Jim.
Mr. Jackson. I was on your 218 panel. You remember?
No, sir.
I was on a panel at 218 and you got denied because you had a 30 seat. You had a write-up.
Yes, sir.
And you were eligible in 2019 and 2020, but you couldn't apply. You had another write-up in 2020. And I'm looking at document right here that you were approved for a hearing on November 19, 2021 by Mrs. Wise, myself, and Mr. Marabella. The hearing didn't happen because you had another write-up.
Yes, sir.
You could have had a hearing in early 2022, but you had a write-up at the end of 2021. I got a problem with all of those write-ups. And you've only served what? You said 15 years?
Yes, sir.
You continuously get write-ups. You don't have that many programs. I think you need to take I think it's called Drug Dealers Anonymous.
I took that.
You took that already, okay. Now, I have another problem. Mr. Freeman asked you, were you a drug dealer or drug user? And you proudly said, I was a drug dealer. I've never used drugs. Why deal drugs and cause a misery on other people's lives and you know from the beginning that drugs are bad for you. Why would you deal drugs causing other people and other people's family misery and getting them addicted and causing them problems in their life when you know it's bad to use drugs?
I never looked at it like that, sir. I just was trying to get the money. I never looked at the problems I was causing. I was just looking for the money.
But you end up sense not to use drugs.
I tried using marijuana before. I ain't like the way it felt, so I ain't tried that else. And I apologize to the people that I hurt and the
You
community.
told me screaming you never used drugs.
Said I tried marijuana when I was younger.
Didn't tell Mr. Freeman that.
That's what I told him, sir.
You did?
Yeah.
Okay, I missed that. I missed that. So you tried it once and you didn't like it.
No, sir.
Why? What effect did it have on you?
Made me paranoid.
But you sold it after that, didn't you?
I tried, yes, sir. I sold it.
Okay, okay. All right. And I agree with the warden. I really agree with the warden. You need to take some more programs. You are a career criminal. You've been in and out of incarceration most of your life, starting when you were a juvenile. And you need to take as many programs as possible. So when you get out, you can stay out. As Ms. Wise said, you have a lovely family. And a family that supports you. And you keep on letting them down. It's about time to think about your family and not yourself. You tired?
Tired, sir. You're right. I agree with you.
You have two lovely daughters who need their dad. You have an uncle that would mentor you and help you with your problem. All you gotta do is extend your hand and say, I need help. Okay. Ms. Harris, the mother of the child, would you like to speak? Would you go up to the podium? Give your full name and your relationship to the offender. Okay.
Speak up. Speak up a little bit.
Yeah, we can't want to hear you. Thank you, sir. Yeah, just talk a little louder, that's all.
Okay.
Yes, ma'am.
Y'all wanna ask me something?
No, just give us your statement. Sir. Move over. That's your statement.
I feel like Sedric should be given another chance because at the end of the day, he's a very good person. I know you asked him, like, why was he selling the drugs or whatever? He didn't state, but he took care of the family the best way that he could. He's always helped people, you know what I'm saying? Like he has a good heart. He may have done the wrong things, but I think that right now I've known him for a long time and I feel like he's changed because his conversation is different. It's just a lot. Like I was 8 months pregnant when he went to jail and my daughter is about 15 years old. She's an honor student and like we go through a lot and communicates with her through the phone. And he's still an inspiration to her, even though he's done all these things. I think that people make mistakes because I too make mistakes, but I just thank God that mine was never in jail. It's just a lot. She's graduating in 2025. And just need, another chance, like, just to be forgiven, just have another chance.
Thank you.
Thank you, Ms. Allen. Thank you so much. Ms. Jackson, the daughter. Give us your full name and your relationship to the offender.
My name is Sedric Jackson. I am the guard at Jackson. I am a 28-year-old social worker for the state of Louisiana. I help the state most mentally ill patients who were addicted to drugs, who had mental illness. So I'm going to read a statement on those from that. I'm not good with public speaking versus advocating and treatment for those patients. So despite my father's significant transgression, I believe Sedric has matured and will be a productive law-abiding citizen upon his release. He feels a great deal of shame and responsibility for his conduct. I believe he has realized how detrimental his choices have been, and I'm convinced he's in a very emotional state. While incarcerated, Sedric has participated in numerous courses. We've had talks, and I have voiced to Sedric the things I see today in people who are addicted to drug use and the effect it may cause on a person and his family. So I believe, and I realize that he will be supported upon his release if he's given parole during this meeting to help him re-enter to society. He has a job lined up as a laborer for a roofing company. He has transportation and a supportive family. Finally, I would like to say, I believe he has changed and he should be given another chance at free. His commitment and personal development has been evident to us, and I hope to you as well. Thank you.
Thank you very much, young lady. Yes, ma'am. Yes, ma'am, you too. Just give us your name and your relationship.
Parole. And Diana is my brother. I just want to say I thank God for a second chance. How God has given each and every one of us a second chance in life. We all have done something wrong in this life, and the God that we serve gave us a second chance. And all I want to say to the parole board, if you can give Sedric Jackson a second chance, I promise you that God will take care of him with the guidance of the church. God will take care of him. Amen. Thank you.
Mr. Jackson, would you like to make a brief closing statement?
Yes, sir. I know I have been a role model inmate in prison, and I haven't been the father that I should have been when I was on the street. But during this incarceration, I've seen and heard a lot of things, and I've made changes for myself, and I try to help the youth that's coming into the prison so they won't make the same mistakes that I've made in prison. I don't regret that I came to prison, but I regret that I didn't take the time to educate myself more when I first came to prison and take advantage of what was placed, why I was placed in here. I never thought about why I was placed in prison until I laid back and realized why I was placed in prison. And that was to become a better person and to get out and be a better person in society.
Thank you, Mr. Jackson. Well stated. Are we ready to vote?
Yes.
Mr. Freeman.
Okay, Mr. Jackson, first off, I want to thank the family for showing up and speaking on his behalf. It always helps us a lot to know that he's gonna have support in the community when he gets out. It gives that chance to go way up of making it. You know, Mr. Jackson, I look at your case and I'm gonna tell you, you know, I was in law enforcement 35 years, probation and parole, so I've dealt with a lot of people. I hadn't seen many people that sold drugs that didn't use them. You may be that one in a million, but I'm just telling you, hadn't seen people that sold drugs in the quantity you were selling it that didn't try to use it. So this is what I'm gonna do with you. I do think you're tired. And I'm gonna take a chance on you, but this is what I'm gonna do. I'm gonna grant you parole, conditional on you going to Steve Hall. I know you say you don't have a drug treatment, a drug problem, but even if you don't have a drug problem, you can go there and see what your selling has done to other people. You know, you can listen to their stories. You can see that the harm it causes to sell drugs out there, especially these days with people dying right and left with them being laced with stuff they shouldn't be laced for. And then you'll be returned to the feds to do your time there. So that's my vote today, to grant conditional on completing Steve.
Thank you. Thank you. Ms. Wise?
Let me tell you something, Mr. Jackson, you brought your A game today. You really brought your A game, because when I was reading this last night, I had no idea I'll be saying what I'm saying. I'm going to grant, I concur with Mr. Freeman, I'm going to grant conditionally upon you completing the Steve Hall. You sit on the front row, you pay attention. You got 4 kids, you got grandkids coming. You're going to need that information. And like you said, to help the young people, you're going to need that information. And after you complete that, I want you to follow the recommendations of that facility, of Steve Hall. They're going to give you some treatment recommendations, follow them. And then I want you to do some community service working with young people, like you had suggested. You got a lot of share your testimony, most of yours for work with the seniors and the young people. Do both, most of yours, you know, do some painting around their houses, at least 8 hours a month. Because one thing I know about drug dealing, you kept long hours. So 8 hours a month shouldn't be a problem for you to do community service. And that's started 3 months after your release. Again, it's because of your family. You put love on these people. For me, you put love on them for me.
Please.
And that's my vote, sir.
Thank you, Ms. Wise. Mr. Jackson.
Yes, sir.
Mr. Jackson. I really think you're tired. So I'm going to vote with my colleagues and give you a chance. You will be transferred to Bossier Minimum, and you must complete the long-term Steve Hall Intensive Substance Abuse Program. Within that program, you have anger management, threatening families. There'll be a series of programs, living in balance. And you sit on the first row, as Ms. Wise said, and see the devastation and destruction that you were putting on your community and the people in your community. After completing the Steve Hall program, I'm going to release you to your federal detainer. And that will be left up to the Federal Prison Bureau to come and get you, and they will have jurisdiction on the 2.5 sentence that you have left in the federal system. You have a curfew when you release from the federal prison from 9 p.m. to 6 a.m. You must follow all recommendations of the Steve Hall program. You are to do community service at 8 hours a month. You're with your parole officer, and he can line up people that need help painting houses, building ramps, whatever it is. I want you to give back to that community that you help destroy with your drug.
And community service begin 3 months after release.
And I want you to attend it. Well, that will be live up to Steve Hall. So basically, you have curfew 96. Follow our recommendations of Steve Hall and 8 hours of community service. That is our decision. We have been granted for completion of the Steve Hall program, and you have been granted to your federal detainer. You have a good day.
Thank you.
Thank you.
You have a good day.
Thank you so much.
What you gotta do, everything else go well.
That is the only one at Allen. It's Warren Thomas. Warren Thomas. That's all our cases for today at Allen. We're gonna stand adjourned at Allen Correctional Center at 11:17. You have a good day, Wardens.
Do the same, thank you. All right. Yeah, that's it.
Always nice to see, I think, the warden shaking hands, encouraging the inmate for a good parole hearing. I thought it was interesting. Miss Wise said, "You know, you're a drug dealer. You're used to working long hours. So, for that reason, I'm gonna order you to do 8 hours community service." There's something interesting about this case and how he got caught, which we'll go over in the records. I found it to be quite interesting. And then also the idea, do you believe that he was actually sober and not a user? You know, his answer when he said, well, why did you never smoke? He said, I get paranoid. I'm able to relate with that. I get paranoid. Now, it's not like a paranoia, like maybe the word, it's not the right, for me, when I smoke, I just get like anxious. Like it's not fun for me. I begin thinking about all the things I need to do and all my problems. And that's like how I describe the paranoia. I just don't enjoy it. I'm an alcohol person. But would be interesting if he really, you know, as Mr. Freeman says, he says it's very rarely, and you know, you hear at least like in the movies, the people that don't use, those are the best dealers. But let's go over his court transcript. What I found interesting, and what it is that the police ended up going into his home without a search warrant. And they had appealed in their court to suppress that evidence. And so let's go look over what it was that led them to that. And to me, it just seems completely, illegal, really, that they got into his house. So basically, they wanted to suppress evidence that they brought to this jury trial. And so they go and they talk about what was happening. When the detective found 1.5 kilograms of Pepsi Cola in the apartment that he was cooking. So he indicated that the defendant Okay, so CI also, so the defendant and Howard had been riding around in the 2003 white Monte Carlo. Howard was known Pepsi dealer and a warrant was outstanding for his arrest for distributing hydro. So approximately 6 p.m., in an effort to corroborate claims, Detective White placed the apartment in question under surveillance. Vehicle described by CI was parked in front of the apartment approximately 7 p.m. Howard exited the apartment and drove off in the Monte Carlo. Now remember, this is Howard. This is not our subject here. Our subject is Sedric Jackson. So he's following Howard in the car, trying to be conspicuous, you know? But that's when the detective realized that Howard realized that he was being followed. So he started making random turns. And the detective said, you know what, I'm busted. So he made the traffic stop. He gave him his Miranda rights, and then he arrested him on the warrant. So remember, again, this warrant was for his associate, not for Sedric Jackson. Howard lied concerning where he had driven from and denied any involvement in the apartment. However, when the police told Howard that they were going to take him back to the apartment to make contact with whoever was inside, Howard became very nervous and protested. And no duh, really? You're going to go and take someone? Can you even do that? Are you even allowed to legally do that once you've arrested someone? Take them back to the apartment and make them announce themselves? Is that legal? Can you be forced to do that? It just seems totally nuts. It obviously is something he could not do if he wanted to remain alive, right? The detective testified that Howard was using a cellular phone when stopped, and the phone also began ringing during the traffic stop. Additionally, a crowd of about 30 to 40 people gathered around the traffic stop. The police became concerned that anyone in the apartment would be alerted to the traffic stop and begin destroying the Pepsi Cola evidence. So the police they're like watching the home because they suspect there's stuff in there. Then they start following the guy in the car who realizes he's being followed. So they're like doing a really bad job at this. Then they arrest him and read him his rights. Then they think it's a great idea to say, hey, let's go back to the apartment, which he says no. Then a crowd shows up and now they're nervous. Oh no, the people are going to know. The stink house is going to know. So we have to do stuff. It just seems like a disaster. They heard someone running inside the apartment. Okay, so the police went to the apartment and knocked on the door and announced their presence. Hi, it's the police. They heard someone running inside the apartment and saw a figure run from the lighted kitchen area to the door area of the apartment. They became concerned for their safety and the safety of evidence, which is so ridiculous. They became concerned for their safety. It's like, what do you... and the safety of the evidence. They call it, and the safety of the evidence. The thing is, are you even allowed to call it evidence if you're not in the apartment, if you haven't, and they kicked their way through the barricaded door. The defendant was apprehended running to the bathroom. The toilet bathroom was running. After securing the defendant, the police obtained a search warrant. You hear that? After they broke in and secured the defendant, then they obtained the search warrant before searching the apartment. However, but you broke in. Now they're saying they broke in because they saw someone running and they were nervous. But to me, I'm just sorry. That just seems, that's like you're stretching that line way too. To me, that's just a violation of rights. Police shouldn't be able to just break down the door. However, numerous dishes commonly used to cook Pepsi Cola with apparent Pepsi Cola residue on it were on the kitchen counter in plain view. An open notebook containing name and dollar amounts written next to them, also on the kitchen counter in plain view. Additionally, a scale and blender with apparent Pepsi residue of them was in the counter in plain view. A trash can containing a wrapper of kilogram was on the counter. A kilogram. Wow. This guy was big time dealing. And a subsequent search of the apartments pursuant before to a warrant revealed 19 1/2 ounces of Pepsi. Additionally, the spindle from an electric mixing bowl was in the bathroom next to the toilet, and Pepsi residue was on the toilet. I don't know. Maybe it was just baking powder and they were cooking, they're having a cooking party. I know. So the motion to suppress evidence, which you think they would have won. I mean, you broke down a door without a search warrant. And I think they're saying that they were allowed to do that because they looked through the window and saw evidence. In his sole assignment of error, the defendant argues that police created the necessarily exigency as a means of bypassing the warrant requirement. I guess they created the idea that they felt they were in danger. United States, so they bring up references here to determine whether exigent circumstances existed. 1, the first degree of urgency involved in the amount of time necessary to obtain a warrant. 2, the reasonable belief that contraband is about to be removed. 3, the possibility of danger to police officers guarding the site of contraband while a search warrant is sought. Information indicating the processors of contraband are aware that the police are on their trail, and the ready destructibility of the contraband and the knowledge that efforts to dispose of narcotics escape and characteristic behavior in person engaged in traffic. The defendant conceded the presence of the 5th factor, but argues none of the other 4 factors were present in the case when the police announced their presence, and thus the trial court erred in denying motion to suppress. Initially, we note that the trial court was under no obligation to file precedent of the federal 5th Circuit in this matter. In state court, federal district, and appellate court cases are persuasive rather than binding. Okay, so the aforementioned cases they brought up as references to why this would be a violation of their rights is not binding because it's different federal versus state, I guess is what they're saying. Further, the court had no need to look at the cases relied on by the defendant to determine whether or not circumstances were present in this case. Probable cause alone does not justify the entry of an area otherwise protected in the 4th Amendment of the United States Constitution. There is justified intrusion of a protected area if there is probable cause to arrest with exigent circumstances are exceptional circumstances when coupled with probable cause justifying entry into a protected area that without those exceptional circumstances would be unlawful. Examples of exigent, gosh, I'm going to have to say this word over and over again, circumstances have been found to be escape of the defendant, avoidance of possible violent confrontation that would cause injury. Did they have weapons on them? No. So, I mean, I guess you could assume there would be, but hey, they didn't find any. Destruction of evidence, the fact that certain factors under the federal 5th Circuit was absent. Moreover, the federal court relied on the defendants are distinguishable on their facts. The government argued that the presence of Mary J. in the defendant's home created an exigency. Gosh darn it, that word. The court found, even assuming that the police saw the MJ in the defendant's home through a screen door. Now they're saying that they saw MJ. It's like there was no exigency as the police undetected and could have attempted to obtain a warrant without creating risk themselves. And I would agree. That's what, exactly. They literally did create the risk on themselves. They followed a guy leaving, then arrested him in what seemed like a high risk area, wanted to bring him back, which just blows my mind that they would even make that as a suggestion, and then bangs on the door and then breaks in when they say that they feel it. You are always going to break down the door if that's your answer. Oh, you thought they were going to open the door and say, come on in. In Vega, while investigating possible dealings at home, the police knocked on the door at the home and announced their presence. The police entered the home through the back. Now they're giving the examples, the references. I don't think we're going to read all that. Okay, state of Louisiana. Let's see what this is. This the result? Welch J. I believe that the police manufactured exception to the exigency justification for a warrantless intrusion into a home applies in this case, and therefore the warrantless entry into the Prescott residence violated the Fourth Amendment to the United States Constitution. In this appeal, the defendant contends that the evidence clearly demonstrates that the police created their own exigency as a means of bypassing warrant requirements, making the officer's warrantless forced entry into the Prescott residence presumptively unreasonable. In support thereof, he relies on federal Fourth Amendment jurisprudence, which has created an exception to the exigency justification for warrantless intrusion in the case of the police manufactured. And then they say, I'm just trying to find out where they come to the conclusion. They're going through a lot of details here of the case, but I'm just wondering, where do they come to the conclusion? Wait. Howard or transpiring, the officers clearly had time to obtain a telephonic warrant, which they eventually ended up doing with considerable ease after right. So that's an interesting point. Remember, they got a warrant immediately after they detained him through a telephone. White telephoned the judge and obtained a telephonic warrant to conduct a search. In rejecting the defendant's claimed police manufactured exigency, the majority findings that was created by Howard's awareness of the police following him and the use of the telephone after the awareness rather than by the actions of the police. However, the circumstances of this case clearly indicate otherwise. If the officers reasonably believe that Howard tipped off the Prescott residence occupants before they stopped Howard in his vehicle, the danger of destruction of evidence would have been imminent, and immediate police action to prevent destruction of evidence would be expected. Yet the officers continued to follow Howard. Oh, you see? This is an interesting point. They're saying, hey, if you really thought that pulling him over and arresting him created the urgency to break into the apartment, that's just can't be true, because then how come they arrested him, read him his rights, spoke to him. That at that moment the urgency would have been created, but you didn't. You took time doing that whole stop. Yet the officers continued to follow Howard, stopped his vehicle, searched Howard, placed him under arrest, conducted a full search of his vehicle, questioned Howard, and returned Howard to the Prescott residence against his wishes, all before making the warrantless entry into the home. Moreover, at the stop, the officers made no attempt to ascertain whether Howard even made it in outgoing calls prior to the stop of the vehicle. As all of these events leading to the officers' return to the apartment with Howard were trespassing, the officers clearly had time to obtain a telephonic warrant, which they eventually ended up doing with considerable ease after forcibly entering the residence without a warrant. Under the facts of this case, I can only conclude that the exigency, there's the word again, created when the officers made their presence known at the apartment was of the officers' own making, and their entry into the apartment without a warrant was unreasonable. In the context of the Fourth Amendment, the single and distinct purpose for the exclusionary rules is deterrence of police violations of the Constitution, protecting against unreasonable searches and seizures. Because the warrantless entry into the Prescott residence under all of the circumstances of this case was unreasonable and violated the Fourth Amendment, the evidence seized as a result of that illegal entry should have been suppressed. Therefore, the trial court erred in denying the motion to suppress. Wait, is that the actual ruling, or is that part of... Now I'm confused. Gosh. I can't tell if that's the ruling of the... or if this is just the cover level letter for the appeal. Because I don't see a signature, I don't see a stamp. I'm sorry, guys, I'm actually confused on this one. I don't know if what we just read was the request of an appeal from his attorney. Or if that was the judge agreeing with the appeal. Or is it possible that... Do I have another... I don't know. I'm actually confused. I don't know if maybe that wasn't the full... I don't know what happened. And I mean, obviously he's been locked up. And maybe it would have made a difference that they would have suppressed that evidence. He still would have gotten caught for something. I'm really not sure. I'm going to put the links in the description. And if any of you know, please do let me know. I'll pin it in the comment section, basically on what the outcome was of this appeal and how they ruled. But in my opinion, you know, our rights, it's so important that they're guarded. And to me, this seems like outright abuse of power. You can know what's going on. You can, but you could have called for a warrant. You didn't. You broke down the door. Then you get the warrant, and that's just not the way it should work. This is not how it works. You got to follow the rules. And when you break the rules, you got to be held accountable. Otherwise, it encourages bending of the rules and breaking of the rules, and that never leads down a good path. So, but that's just my opinion. Love to hear yours. And with that, I'll let you go.